Yeah, I think that's fine. Good morning. My name is Eddie Lazarus, and it is my distinct privilege to be the moderator of this panel examining backlash and attacks on landmark decisions from Brown to Roe to Goodrich. Certainly a very timely panel. Obviously, we've just finished up a Supreme Court term in which the attacks on landmark decisions were quite evident, from the late-term abortion case to the school pupil assignment cases from Seattle and Louisville. But I think beyond just thinking about this in terms of last year's Supreme Court session, this is really a topic of broad significance for the progressive movement. It really boils down to the question of what role courts should play in the progressive agenda. Baby boomers like myself have grown up in the shadow of the Warren Court, thinking about the Supreme Court in particular as an agent for social reform. But in more recent times, a wide body of scholarship has grown up suggesting that those judicial victories were in many respects Pyrrhic victories because of the political backlash that these various decisions have created. And we have with us a very distinguished panel with wide-ranging views on this subject to discuss this issue with us today. I could take up pretty much all 90 minutes just reciting the credentials of the various people up here on the panel with me. I'm going to give a very abbreviated version with apologies for leaving out many of their extremely significant achievements. And I'm going to introduce them in the order in which they're going to make presentations. After they give their set pieces, I'm going to invoke the moderator's prerogative of asking a few questions of my own, but we're also going to take questions from the studio audience. And George over here, I want you to stand up, George, so people can see you. He's going to be coming around. If you have questions that you'd like to be addressed, please grab a note card and a pen from George, and he's going to hand those up to me, and we'll get to as many of those as we have time for. First up today will be Jeffrey Rosen, who's well known, I'm sure, to all of you as professor of law at George Washington University Law School, longtime legal affairs editor of the New Republic magazine, frequent contributor to many other publications, and he's written most recently The Supreme Court, The Personalities and Rivalries That Shape America, but perhaps more salient for this discussion today was his previous book, The Most Democratic Branch, How the Courts Serve America. Next up will be Scott Lemieux, who is an associate professor of political science at Hunter College in New York. His key areas of study are judicial politics and comparative constitutionalism and reproductive rights. He's written frequently for the American Prospect. He's an extremely well-known and well-respected blogger. And he's written some of the most thorough and thoughtful and empirical analyses of this issue of backlash. We have a dynamic duo from my alma mater, the Yale Law School. Reva Siegel, who's the Nicholas Katzenberg Professor of Law and American Studies. Her academic work focuses on how courts interact with representative government in interpreting the Constitution. She is the co-author of leading treatise, Processes of Constitutional Decision-Making, sits on the board of the American Society of Legal History, and the National Constitution Center. As particularly salient for this discussion, she is the co-author with Robert Post of an article called Roe Rage, which examines the issue of backlash. Robert Post is the David Boies Professor of Law at Yale. He teaches many subjects, including constitutional law and legal history. He has a PhD from Harvard in the history of American civilization. He also is the author of many, many well-received books. And his most recent project is he is writing, and this is a very, very high honor in legal academia, he is writing a volume of the Wendell Holmes Devise, I believe it's volume 10, that will be dealing with the Taft Court. And batting cleanup for us, Roger Wilkins, Robinson Professor of Humanities and Social Science at George Mason University. But I think for purposes of this discussion, this is someone who has not just written and studied the idea of backlash. This is someone who has lived backlash. He was, among other things, the Assistant Attorney General in the Johnson administration. He is a Pulitzer Prize-winning journalist for the editorials he wrote for the Washington Post during the Watergate era. He's written a fascinating autobiography called A Man's Life. And he also, just as a little side point in his career, interned with Thurgood Marshall at the NAACP during Brown versus Board of Education. So you can see you're in for a real treat this morning. And with that, I'd like to turn it opening remarks of roughly 7 minutes. I'm not like the Chief Justice. I will not slam my hand down on the table at exactly 7 minutes, but somewhere around there. Jeff, would you start it off for us?
Thank you so much, Eddie. And it's always a pleasure to be at the American Constitution Society. When this panel was first convened several months ago, liberals were worried about the possibility of a backlash against liberal decisions, such as Roe versus Wade and Goodrich. But now, at the end of a bitterly divided Supreme Court term, liberals are in the mood for a backlash of a different kind, namely a backlash against the conservative excesses of the Roberts Court. And just yesterday, in the New York Times, Jean Edward Smith, author of the superb and definitive biography of John Marshall, wrote, "If the current five-man majority persists in thumbing its nose at popular values, the election of a Democratic president and Congress could provide a corrective." I've come to rain on the parade of liberal as well as conservative backlash enthusiasts with a point that may be so obvious that I hope you'll forgive me for belaboring it. And here it is. The court only provokes intense national backlashes when it does things that intense national majorities intensely oppose. And there have been only 3 periods in the court's history when the backlashes it's provoked have been intense enough to lead the justices to abandon their views. As for the Roberts Court, as long as it's led by Justice Kennedy, who has his antenna tuned to the attitude of the median American voter with exquisite precision, it's unlikely to provoke significant national backlashes. Still, if the Roberts Court continues down this path and starts striking down laws that Americans do care intensely about, such as environmental laws and health and safety laws, it could indeed provoke a backlash of national proportions. What's the historical point about the relationship between backlash and popular opposition? Gerald Rosenberg makes it well. He notes 3 periods in the court's history when there's been an intense reaction to its decision that's led the court to abandon its views. First, the Marshall Court's response to the Jeffersonian Republicans' attempt to curb its jurisdiction. Second, the response to Dred Scott and Lincoln and Johnson between 1858 and 1869. And finally, the New Deal Court's switch in time in 1937. In all that cases, very unpopular decisions, congressional backlash, and the court abandons its views. But there are less dramatic backlashes. There have been 3 other periods, Rosenberg notes, when there's been less intense national opposition that's led the court to modulate its views without abandoning them entirely. And those include the resistance to the Marshall Court's nationalizing decisions at the beginning of the 19th century, the assault on the Warren Court's efforts to defend the free speech of communists and anti-communists in the 1950s, and finally, and we'll talk more about this today, the response to Roe v. Wade. In other periods, opposition has been so diffuse that it hasn't led to a meaningful change in the court's views, and that's the response to Lochner by the progressives, or the response to the Warren Court's school prayer decisions by social conservatives in the 60s. There was opposition, bills introduced in Congress, but it wasn't focused enough to actually lead the court to change its views, and the court stood its ground. What about Brown and Roe and Goodrich, the topic of our conversation? Let me just make the obvious points quickly. Brown, as Michael Klarman has argued, was popular with 54% of the country when it came down in 1954. It inspired opposition mostly among Southern minorities. Its main effect was to galvanize the civil rights movement. The civil rights movement, Klarman argues, when it was set on by police dogs in the South, and those television pictures were broadcast to the nation, provoked so much national outrage that finally Northern voters were galvanized and the Civil Rights Act follows. But the idea that Brown by itself led to meaningful integration is not a case that can easily be sustained. What about Roe v. Wade? Roe v. Wade, and this is the polls are actually easy to state. Since Roe came down, the Gallup polls haven't changed much. 2/3 of the country has consistently supported the right to choose early-term abortions. By the same token, larger supermajorities, 70 or 80%, oppose the right to choose in the second and third trimester. And those numbers haven't changed much. When Roe came down then, the central holding that first-term choice should be protected wasn't unpopular. It was popular with 52% in a Harris poll. It was Roe's efforts to rule out of bounds more popular and more modest restrictions on late-term abortion, including parental consent periods and waiting periods, that proved nationally unpopular. Between 1973 and 1982, Congress enacted 30 laws restricting abortion. Roe also galvanized the pro-life movement. It led to the creation of interest groups on both sides of the political spectrum that dedicated themselves to preserving and overturning it. And the important point here is the court modulated without abandoning its views. In Casey versus Planned Parenthood in 92, Kennedy and O'Connor and Souter, with exquisite sensitivity to public opinion, precisely embodied it. They said early-term choice has to be protected, but late-term choice may be restricted. And Carhart, the recently decided partial birth case, despite its unnecessary and paternalistic lucubrations about the need to protect women against so-called abortion trauma decision, was not in its central holding counter-majoritarian, because partial birth abortions, especially in the late term, are opposed by bipartisan majorities of Democrats and Republicans in every state in the nation and in the Congress. To the degree that Carhart affects pre-viability abortions, it gets a little trickier, but the fact that, as the court itself conceded, the law would not ban any actual women from having actual abortions because it assumed the availability of an equally safe procedure in all cases makes it foolish to hope that Carhart itself will provoke a dramatic national backlash. And what of Goodrich? Lawrence, the sodomy decision, was popular with 60% of the country in a Gallup poll. There's no constituency, even among most conservatives, for banning consensual sodomy. By contrast, gay marriage is a position rejected in national polls by 2-1 when Goodrich was decided. There was a localized backlash to Goodrich. 13 states added to their state constitutions amendments that banned gay marriage, even though before Goodrich only 4 states had those on the books. Some analysts think it may have made the difference for Kerry in states like Ohio. Others dispute this. The point of Goodrich, certainly like Roe, or perhaps even more like the school prayer decisions, a state court decision, not national, didn't provoke a national backlash, but had moderate backlashes and counter backlashes. So that's the obvious point. Only when things are really intensely unpopular with national majorities is there a big backlash that leads the court to change its views. Where does that lead the Roberts Court and liberals and progressives who are concerned, as Jean Edward Smith put it, that the court may be thwarting the views of popular majorities? Alas, I have to report that when I survey the leading decisions of the last term, I find it hard to conclude that they were intensely counter-majoritarian. The partial birth decision wasn't, for the reasons I've already described. Affirmative action, a trickier case. There are backlashes and counter-backlashes. When the court upheld the University of Michigan Law School's affirmative action program in 2003, Michigan voters repudiated it in a referendum. But there are also backlashes in the opposite direction. When a Texas court banned affirmative action in the 90s, the Texas legislature resurrected it with a so-called 10% plan. As for the Seattle case, these programs exist in very few school districts in the country, 5% according to estimates on both sides. Many believe that even in places like Seattle and Louisville, administrators that are determined to keep them going may be able to do so. So the practical effect of the decision may be limited. For all these reasons, although I found the Seattle decision an unconvincing example of conservative judicial activism, I wouldn't bet on it provoking a backlash. And then think of the rest of the cases. Kennedy's decision upholding the power of school principals to discipline students and limiting challenges to public funding of religion. These aren't likely to provoke a widespread rebellion either. But the future is not entirely bleak for liberals who hope for the possibility of a backlash. Right now, Kennedy's in the driver's seat, but it's not at all inconceivable that there could be a six-man or six-person majority to join Justices Scalia and Thomas in their crusade in the future. And if that's the case, I could imagine the court doing things that national majorities intensely oppose. If the court were to overturn Casey and to say that early term choice may be restricted, this position, unpopular with 2/3 of the country, might lead moderate GOP men and women to desert the party in droves. And in a country at parity, that could make the difference for the Democrats, which is why many of us pro-choice Democratic critics of Roe think that the demise of Casey might ironically be one of the better things that could happen to the Democratic Party. But that could provoke a backlash. And then think about the cases associated with a movement that some of us have called the Constitution in exile. Cass Sunstein and I were ridiculed a couple years ago for suggesting that the conservatives were on a crusade to reverse environmental laws and health and safety laws. But as the recent decisions involving the Clean Air Act and greenhouse gas suggest, our fears are by no means hypothetical, and I can imagine if it were not Kennedy but a reliable conservative who were in the driver's seat, the court actually striking down these laws, and these are things that people do care about, and at that point, especially with a Democratic president or Congress, I can imagine a meaningful confrontation between the court and Congress, perhaps in a way that we haven't seen certainly since Roe and maybe even since the New Deal. So there may be hope or trouble ahead on those lines. But the broad point, and I'll now conclude, is that it would be foolish for liberals to put too much faith in the courts right now, and they don't have to, because on many of the great issues that are most contested now, abortion, I think ultimately affirmative action, campaign finance, and environmental laws and health and safety regulations, we have public opinion on our side. We no longer need judges to fight our battles for us, and to the degree that judges thwart these intensely held national views by unwisely resorting to conservative judicial activism, liberals can respond with the cool and convincing voice of bipartisan judicial restraint. Thank you so much.
Yeah, I give you fair warning that I'm sure some of the panelists are, and if they don't, I will probe your views about some of the more activist liberal decisions and your criticisms of them. But you've given a wonderful historical description of the backlash phenomena. And Scott, I have a feeling, since I've now read a couple of hundred pages of your work, I will probably take issue with a few of the things you've said empirically.
Well, what's amazing is that when I started this interminable work many years ago, I was actually a believer in the backlash thesis. I expected to find that litigation would actually produce more opposition than other forms of change. And as I looked into it with respect to the issue of abortion, I found, and the backlash thesis was believed by people on both the left and right. It wasn't just kind of politically interested. And I found that, it was a pretty convincing thesis, and the only things wrong with it was that there was no theory and there was no evidence. Other than that, it was completely airtight. But those are the only two flaws. I won't talk in my initial remarks about my kind of, why I've, on reflection, not really found it theoretically convincing, I think, because I know Professors Post and Siegel have some interesting things to say about that, and I think it'll come out in the discussion. So what I'll do is briefly explain the reasons why I think that empirically the idea that courts produce a greater backlash than other political change achieved through other institutions is not an empirically solid thesis. And this is not to say that decisions like Brown and Roe and Goodridge don't produce a backlash. We know that they do. But if that's all that we're arguing, that's a fairly trivial claim. I mean, we can avoid backlashes by just never winning, and sometimes it seems like that is our strategy. But obviously nobody, advocates that. So the real question is, does using the courts produce more of a backlash than using other institutions? And on this issue, unfortunately, or fortunately, or whatever, I actually don't really buy it. And I should say that I think this is not only true of decisions I approve of, but I also think this is true, regrettably, of many decisions that I don't approve of. I wish that Professor Rosen had been right when he said that after Bush versus Gore, the court had committed suicide, but that the decision didn't seem to produce as much of a backlash as might have been expected. So this isn't just about whether I agree with what the court is doing or not, but I think that the idea that the courts produce a unique backlash isn't very well founded. So let me explain some of my reasons for this. When it comes to Roe versus Wade, the key, obviously, is to look at what was going on at the legislative level before Roe. If the backlash thesis is correct, and this is my biggest misunderstanding, that I kind of bought this romanticized idea of what was going on before Roe, which is that state legislatures were slowly but surely moving towards liberalization, and the court may have sped things up a bit, but it did so by provoking a big backlash. What I think a lot of people don't understand is that, for all intents and purposes, abortion legalization at the state level had stopped by 1973. That most of the initial liberalization came during a brief flurry in 1967 before the pro-life movements got organized. And you had some states liberalizing entirely, only 4, sometimes provoked by state litigation, and you had some other states engaging in kind of compromise legislation that would insulate doctors from prosecution but not provide, would still criminalize abortion in some circumstances. But by 1973, abortion was still illegal, was not fully decriminalized in 46 states and was still illegal entirely in 37 states, despite public opinion that's very similar to today, and it wasn't really getting any better. By the time of Roe, pro-life groups were extremely well mobilized. Reform attempt after reform attempt were failing. Referendums were losing. So essentially, the movement was largely dead by 1973. And there are a variety of reasons for that, but the most important are that American legislative institutions are not particularly majoritarian, especially when it comes to changing the status quo, that it's much harder to get legislation repealed once it's entrenched. And the second problem where abortion is concerned is that, for all intents and purposes, abortion laws are only applied against poor women. That affluent women in urban centers almost always have access to safe abortions anyway, so the people who have the biggest stake in decriminalization are the women with the least political power. So because of this arbitrary enforcement, it's harder to get abortion legislation repealed, even when public opinion supports it. So for that reason, it's simply not true to say that Roe created the pro-life movement, or that there was sort of an inexorable wave towards legalization before Roe. Basically, the movement had stopped, and it was going to be difficult once we cherry-picked the most liberal states to liberalize in a lot more states. And I think without Roe, abortion would still be illegal in somewhere between 15 and 25 states today. So that's sort of my my first argument. There are a variety of other pieces of evidence we can look at. Unfortunately, there wasn't the well-developed conservative media then that there is now. But one interesting thing is that if you look at the National Review at that time, you'll find that there were more articles about abortion in the 3 years before Roe than in the 3 years after Roe. So this is clearly something that was on the agenda of movement conservatives. And if you read these articles, it's pretty remarkable. Bill Buckley's writing these editorials like, here's our 4-point plan for stopping abortion. We're going to picket clinics. We're going to write op-eds. We're going to compare them to, the people running Auschwitz, et cetera, et cetera, et cetera. So, movement conservatives were, very aware of this issue. I mean, it's connected to a lot of their sort of broader concerns. And they were clearly conscious of it and mobilizing about it before Roe. Roe made it national, but that's only because, again, it was a victory. But there clearly was a lot of counter-mobilization at the state level that was, in fact, very effective. And as Professor Rosen noted, public opinion on abortion has been relatively consistent. The backlash hasn't shown up in terms of, increasing opposition to legal abortion. And I think perhaps the most interesting fact, if we're considering whether overturning Roe versus Wade would be good for reproductive freedom in general, is that Roe, if anything, actually polls better than its underlying policy goals. Roe is consistently supported by a 2-to-1 majority, and you can see this during presidential debates and confirmation hearings. Democratic candidates are very explicit. Our candidates will support Roe versus Wade. When you ask Bush about Roe, he looks like someone's approaching with a cattle prod and starts babbling about slavery, whatever, So conservatives are not explicit about wanting to overturn Roe because they know it's not popular. Which I think is inconsistent with the idea that resolving this through the courts was really damaging to reproductive freedom. So for all these reasons, although it's hard to know, I don't think that the backlash to Roe or the backlash to abortion rights was created by Roe versus Wade, and I certainly don't think that it would be better for reproductive freedom were Roe versus Wade to be overruled. When it comes to Goodridge, again, I think what happened recently in Massachusetts is quite remarkable. If the backlash thesis was correct, we would expect the cause of gay marriage to have been set back both in Massachusetts and throughout the country. Instead, what's happened is that gay marriage has become more popular in Massachusetts as Goodridge, And we went from having a majority of legislators opposed to gay marriage to not even be able to get 25% of the vote to bring a constitutional amendment that would repeal it. So that's quite a remarkable shift, which is precisely the opposite of what the Backlash thesis would predict. Gay marriage has actually become more popular, and legislators, even if they weren't crazy about giving the rights in the first place, are very reluctant to take them away, which is an interesting dynamic. And some other states have, continued to enact civil unions. And in the states where there were referendums passed after Goodridge, these were all states, for the most part, in which there weren't civil union or gay marriage rights, in which there was no prospect of it. So particularly since state constitutional amendments can basically be overturned like ordinary statutes for the most part, it's not clear how much this hurt the status quo. It hurt it a little, but not to an enormous amount. And I think a majority of the voting behavior analysis suggests that gay marriage was not a decisive issue in the 2004 election. And you may recall some people saying that when the New Jersey courts mandated civil unions before the 2006 elections, that this was going to be a disaster to Democrats, it would mobilize social conservatives, and you're probably not hearing much about that now for obvious reasons. So I guess one problem I have with the Backlash thesis is that some of its proponents have predicted 8 of the last 2 backlashes. So it's important to remember when predicted backlashes don't happen. And just very briefly, another thing I did in my dissertation was to try to bring some comparative perspective. I mean, one problem I have trouble convincing people about the American case is that people can see that there was a reaction to decisions like Goodridge and Roe, and we can play a counterfactual game, but it's still hard to know, what would have happened otherwise. Maybe a whole bunch of states would have liberalized without Roe, we don't know. So one thing I've done is looked at our neighbor to the north and seen what's happened there. That if the key variable is litigation, this should show up in other countries other than the United States. What's interesting is that Canada, first of all, has the most liberal, or one of the most liberal abortion regimes in the Western world. It's almost unregulated, state-funded, and this was created by a decision, a Canadian Supreme Court decision about 20 years ago, and despite this, abortion is not a particularly salient issue in Canada. The policy has been completely stable. It hasn't been especially divisive. So in that case, litigation doesn't seem to have produced a major backlash. And similarly, Canada had a very litigation-driven legalization of gay marriage at the federal level. And there was recently an election. A new conservative government came in. They made one desultory attempt to repeal the grant of gay marriage. Several members of Prime Minister Harper's own cabinet voted against it. And Harper said right afterwards, after his attempt to repeal it had failed, that we don't plan on ever bringing this issue up again. Essentially, for us, it's closed. So again, it seems that the litigation-driven creation of gay marriage in Canada has not produced any kind of backlash, and in fact, gay marriage continues to be more popular and entrenched. So I should, in conclusion, say that this is not to say that I'm completely Pollyannish about litigation. As will come out in discussion, I do agree with some aspects of what people like Professor Rosen and Jerry Rosenberg and Michael Klarman have argued. But on this narrow issue, my view is that issues like abortion and gay rights and civil rights are divisive because they're divisive. And this divisiveness was not created by litigation, and nor do I think that this divisiveness will go away if progressives sort of unilaterally disarm and stop using the courts.
Thank you, Scott. And I'm going to turn now to Riva, who has looked at this issue from not only an empirical standpoint, the way Scott has, borrowing, I think, on some of Scott's work, but also very much from a theoretical point of view of really what role should courts play in the constitutional interpretation, and what is the interplay between those courts and any backlash that does occur.
Okay, so what I'm going to do is something near to impossible, which is I was told that I had 3 minutes to speak because
You can take a few more than that.
Robert and I are presenting something together here. So I'm essentially going to be presenting the first end of a very short account of the paper that we've recently done, which is called Roe Rage, Democratic Constitutionalism and Backlash. Like the title. So, so the paper essentially starts by looking at a very common view of backlash, namely that it's bad. And it's bad either because it represents popular resistance to authority, disrespect of law, threat to judicial independence on the one hand, or on the other, because it's in fact a form of popular response to judicial overreaching. And I think that this is a view that Jeff is speaking from now. The idea that what you're looking at backlash, you have a sign of something gone wrong because courts have strayed from their proper role, and in his account, they've entrenched upon consensus understandings, et cetera. The paper that we've done essentially is offering an alternate view of what we're looking at when we're looking at backlash. Rather than starting from the assumption that backlash is a social ill or a wrong that needs to be remedied or avoided, we are writing from the view that backlash is something like a normal part of the constitutional order in which we're living, and that it has many benefits as well as some obvious and indisputable costs. So where would such a sort of vantage point get off the ground? The first place that we start is by thinking about the question of the Constitution's authority, about the Constitution's authority as law. The Constitution's authority as law, in the end, is democratic. It's the Constitution, and it's authoritative to us because it's our Constitution, because we recognize it as our Constitution. It does not have authority except as we recognize it in those terms. The question becomes, how is it that the Constitution's democratic authority is sustained over time from generation to generation? There is a conventional answer to that question. The answer is the authority of lawmaking. The founders went through a procedure, and in fact, if we want to change anything that we've inherited from them, we have available to us the procedures of Article 5 to alter the Constitution. We observe here and in other work that the lawmaking paradigm is insufficient to account for how it is that the Constitution's democratic authority is sustained from generation to generation. Here we're not arguing something normative, we're observing interpretively something about the nature of the constitutional order in which we're all participating. Namely that, rightly understood, carefully observed, we see that there are multiple mechanisms and feedback loops that sustain the authority of the Constitution over time. In addition to, not instead of, but in addition to the lawmaking framework, we have the whole process of electoral politics, which controls judicial nominations and appointments. Obviously, a huge point of democratic input to the constitutional order. You can think about all of the various thoughts of jurisdiction stripping, or in the New York Times recently, court packing. You can think about the role that state, here I'm just being incredibly summary, state legislation and state constitutional interpretation plays in beginning to articulate or question norms articulated in the federal system. You can think about other multiple mechanisms of norm contestation in civil society, protest movements, civil disobedience, the like, the sit-ins, what have you. There are a variety of all of these mechanisms. All of these mechanisms, in fact, are the stuff of what we're talking about when we talk about backlash. Right? These are the mechanisms through which backlash is conducted. So we have something about the how here. Now, coming back to the question of, is this basically something gone awry, or is there something good to be said for what we're looking at when we're looking at the phenomena of backlash? It's plain that when all of this is going on, it is a threat to a constitution which vindicates both rule of law as well as democratic self-governance values. It is a threat to role authority of judges, and it tears at the social fabric. We do not mean to minimize the cost of what happens when the various forms of interaction that we refer to, roughly speaking, as backlash occur. We're not disputing this. The question is anything ever gained through this? Is anything of social value or system value produced through it? And what we start out by arguing in this paper is that, indeed, there is. Those values will not be visible to us if we start from the assumption that the Constitution already has authority, or alternately, that it has authority in essence because it's simply reflecting what are the homogenous views of the American people. They agree. This is a little bit the consensus account that Jeff is putting forward, namely that there is a consensus out there and the Constitution reflects it, and that's that. It also won't be visible to us if, in fact, we think that people should just defer to authority, meaning that when they're told what the Constitution means, they should listen and submit. If that posture is acceptable normatively, then indeed backlash more or less looks like costs and social violence. On the other hand, If you start to question any of those assumptions, you begin to see why it is that backlash, as well as incurring costs, also has social goods to contribute. If you notice that, in fact, we did not participate in the framing of the Constitution, but it was handed to us, and the question of how it's ours is always an issue for us. If you notice the fact that there's deep normative heterogeneity in the American polity, namely that people disagree with each other quite passionately about matters of moment, right? Then you can see that the question of sustaining the Constitution's authority over time is much more complicated, and in fact, we may have complex social mechanisms for achieving this. We offer in the paper, since I'm doing the 3-minute version before Robert goes, I'll just say 2 things here. We offer in the paper an account of how it is that, in fact, what we're looking at when we're seeing backlash could have constructive social effect. There's forms of communicative action going on when there's popular resistance to judicial overreaching, as Jeff is pointing out. So there's ways in which there's democratic steering. There's also attaching. People are struggling to speak to each other about the meaning of a shared tradition. They're struggling to speak in the name of we the people. Therefore, they have to render themselves intelligible to one another. And that struggle, that debate, that attempt to make claim on a shared history and shared modalities of interpretation and say what the Constitution rightly understood means is itself a form of community in conflict. That is the sort of core foundational frame of this paper. We also observe that not only are there system goods to seeing this about the nature of social or constitutional conflict, but there may be goods for liberals, if you'll excuse the phrase here. And that is that we might see liberal writing on backlash in part as suffering the trauma of the rise of the new right, a sense of dread about the forms of social practice that put in peril the Second Reconstruction, the Great Society, and more. But there is this question of what it is that liberals see in the coming decades as they live in the current judicial system, what they're likely to find insofar as their relationship to the courts is concerned. It may be time to look back at what it is that conservatives did in the 1970s when they faced a judiciary that was construing the Constitution in ways that felt normatively alien to them. And here I'm going to turn this to
Robert? Thank you. So I'm going to pick up from where Reva left off and just very, very quickly talk about some implications of this analysis for where we stand now with respect to this question of abortion. And I want to start with a certain premise. If you think back 10 years and you think the way progressives regarded courts, courts were the fora of principle. Courts where it was the forum where rights were vindicated. And now what do we have? We have popular constitutionalism, we have minimalism, we have liberals turning away from courts. The question is, why is that? One reason that is the case is that we are traumatized. We've been traumatized by the rise of the new right. We are so afraid that if we do too much with courts, we will provoke a reaction that will strip us of what we've gained through courts. And what I'm going to do is talk very briefly about that perception. It's absolutely explicit in a number of writers, like, for example, Cass Sunstein, that the problem is if you go too far with a decision like Roe, you provoke a backlash, and everything you wanted gets swept away. And so the question is, historically, is that true? What actually happened with the backlash to Roe, and what implications does that have for us normatively now? So if you go back and look at when Roe was decided in '73, there was, as Scott says, opposition to the liberalization of abortion. It was chiefly Catholic in terms of being mobilized, and it was opposition to the legislative liberalization of abortion. It wasn't specifically to anything judicial. It was opposition to abortion per se, and it was by a certain group of people, namely Catholics on the whole. If you read Jerry Falwell's autobiography, he says at the beginning of it, I woke up one morning the day after Roe was decided, and I read about this baby-killing machine. I knew I had to be in politics. It turns out it's false. It turns out that there wasn't major organized opposition to Roe that arose immediately after Roe to the decision. It took about 3 or 4 years for major backlash to the decision as a decision to arise. And why is that? Our account, the liberal account that you will read endlessly in the pages of liberal academics is that the court in Roe overstepped. It made judicial mistakes. It didn't give the right rationalization. It went off on due process instead of equal protection, or it went too far, et cetera, et cetera. This is how academics talk to each other, but this is not how you create a social movement. People in the world don't care whether Blackmun got his reasoning exactly right. That's not why they go into the streets. Why did they go into the streets after Roe? And here we're going to point to three phenomena. The first is, in the 1970s, abortion was in the process of changing its meaning. When Roe was written, it was written from the point of view of the fact that abortion should be a doctor's issue. We should protect doctors. But at the very same time, the women's movement was making abortion into a woman's issue, that is, a woman's right. And this change in the meaning of abortion got emphasized in the ERA debates when Phyllis Schlafly said, it's abortion which is at the heart of the ERA. And what does that mean? It's about women going out of the home and being independent wage earners. So when we're opposing abortion, abortion has suddenly become the meaning of women outside of the family. And if you look at the opposition, for example, when Phyllis Schlafly attacks it, she attacks the ERA as a total assault on the role of the American woman as wife and mother, and accuses the ERA supporters of promoting federal daycare centers for babies instead of homes and promoting abortions instead of babies. Daycare centers and abortions put together. Right? And this conjunction keeps occurring throughout the decade. So by the time abortion enters the Republican Party platform in 1980, and it stays this way to the present time, the Republicans pledge, quote, to work for the appointment of judges at all levels of the judiciary who respect traditional family values and the sanctity of innocent life. The sanctity of life and traditional family values are yoked together because it's the same issue. Abortion has become a woman's issue, so the mobilization of Roe by the decade's end is a mobilization against women's equality. That's the first point. Second point, you see a second strand to the mobilization against Roe, which is a religious strand. And that is Catholics and evangelical Protestants in the United States had never been allied, ever, in the history of the country. They come together in the late 1970s over abortion. So Falwell doesn't preach against abortion until the middle 1970s. The Baptist Convention doesn't oppose abortion for therapeutic purposes. These are the evangelical sects as of the time Roe was decided. But by 1976, 77, you see a joinder of Catholic and evangelical Protestants over in opposition to secular humanism. And what do they mean by that? They mean that the state has been taken over by secularists who want to read religious values outside of the government, outside of the state, outside of our public policy. And so a mobilization against abortion and against Roe begins to stand for take back the state for religious values and for religious purposes. And the third point here is that this alliance between evangelical Protestants, the moral majority, and Catholics, which is a new phenomenon in American politics, is brokered by Republican Party operatives like Paul Weyrich and Howard Phillips, who meet with Falwell in 1979 in Virginia and say, we ought to form a mass political movement that ought to be Republican in orientation against the Democrats, and abortion ought to be the central link which unites working-class evangelical Protestants and working-class Catholics against the traditional Democratic alliance. And so this is brokered as a self-conscious political deal. So what does that mean? I'll be very brief. It means that the true backlash to Roe, which is the rise of the new right, is really the reflection of a constitutional vision, what Robert Cover used to call a nomos. And that constitutional vision is traditional family values, women stay in the house, and a religious state, meaning opposition to taking the Bible out of schools, which is a major source of this for the religious right. Now, is minimalism a way to fight a constitutional vision? I want to suggest to you the answer is it's implausible to think it, because these people are electing presidents who cater to this, who will appoint judges, who will interpret the Constitution in light of this vision. And how do you fight a constitutional vision? Not by minimalism, but by countering it with your own vision, which means that you can't imagine that by abandoning Roe, you are going to succeed in this, because this constitutional vision is much more than abortion. It's about equality, it's about religion, it's about a secular state. And you have to fight it politically and you have to fight it judicially, both. And that would be the appropriate implication for liberals to take from the backlash to Roe.
Thank you, Robert. I was interested in your summation there before I turned it over to Roger, in that Cass Sunstein, while being the author of Minimalism, has also called for a new progressive vision. And I wonder how, if he were up here, he would reconcile those two, and perhaps we can talk more about that as we get to the questions. Roger, the floor is yours.
Thank you. I think there's a need on this panel for a plaintiff to speak. And since I am not a gay man, nor am I a lesbian, get that? Hear it? And I am not a poor, pregnant teenager. So for the purpose of this discussion, I'll pretend to be black. The work that I object to is done by University of Virginia law professor Michael Klarman, who, among other things, suggests that Brown v. Board might well have been a mistake, that progress was being made in the South, and that Brown elicited a massive backlash which has been destructive of the interests of Brown ever since. Brown was a shot at segregation. Let me tell you something. I have to describe your plaintiff a little bit for you. I am a 75-year-old natural-born citizen of the United States, if you can call natural-born being born in a segregated hospital in a segregated town in a segregated state in the middle of the country, Kansas City, Missouri. My understanding of what segregation meant, I got from the strongest human beings I knew, and that was my parents and their friends, all college graduates, all, as I now understand it, with their lives being defined, squashed, and diminished. And I learned what I learned about segregation from listening to them as they sat and talked to each other, and almost always in their social discussions, ultimately, the crushing, soul-breaking weight of segregation became the central subject of the conversations. As I grew up, I learned that my parents and their friends were right. I learned, because of segregation or the racism in Grand Rapids, Michigan, where I ultimately grew up, that your soul could be shattered by any white person who just happened to be having a bad day and didn't like black people and decided to do something nasty. Whether it was a clerk in a store or a policeman or just an adult dealing with a kid. Segregation wasn't just in the South. It's in the North, too. I went to the University of Michigan for 7 years, college and law school. Now, don't get me wrong, I love the University of Michigan, and I am totally convinced that the source of all evil in the world is located in Columbus, Ohio. But I went to the University of Michigan for these 7 years, 1949 to 1956, and I was never assigned a book, a poem, a short story, an essay, or a play that was either written by a black person or suggested that any black people had ever done anything constructive in the history of the written word, with one exception. In con law, we studied Brown v. Board, which had just come down the previous year. Well, there's a black guy who had done something named Thurgood Marshall. I say those things to suggest to you that the real result of segregation was to put black people in a defensive crouch in our souls all the time. And in a country where robust, vigorous, unending effort is required for success, I want to tell you a defensive crouch is not really the way to begin any day that's going to be successful. Brown cracked segregation. Sure, there was a backlash. But there's always been a backlash in this country when something good happens for black people. There was a movement after the Revolution in the 18th century for northern states to abolish slavery. Now, yeah, what happened was that the southern states began to import more and more slaves and send them down to the southwest of the South. The slave trade became more vigorous, but the fact is that lots of black people in the North became free. Not all of them, but lots of them. I don't think that those black people who became free in the 18th century would have had a trade-off, oh, we'll stay in slavery so there won't be a backlash and it will all be quiet the way it's always been. Of course, in the 19th century, there was first Reconstruction, then there was about the most vicious backlash you can imagine. Ku Klux Klan, Knights of the White Camellia, terrorism of a degree and kind that you just cannot, in your mind, think of being a part of the fabric of American culture, but there was. But did black leaders decide that the thing that they wanted to do to stave off this backlash was to go to the Congress and say, gee, it would be a good idea if you got rid of the 13th, 14th, and 15th Amendments? They didn't, and of course, they were right. Then in the 20th century, there was Brown and the aftermath. I can tell you, I do not believe that had Brown not come down, that the Montgomery bus boycott, which followed the next year, would have occurred. Matter of fact, I knew Mrs. Parks, and one day I asked her, I said, Ms. Parks, now she was the secretary of the NAACP branch in Montgomery. I said, Mrs. Parks, what made you do what you did that day? And she said, well, you know, we had been trying to take a stab at segregation for a long time. But then we started to try it once, but it didn't work out. And she said, you know, I think it was Brown just made me say, this stuff has got to stop. And that was the day that I kept my seat. Brown produced Martin Luther King. Brown produced an awful lot. Now, Klarman says, well, it didn't produce a lot of segregation. Well, that's true. But one of the reasons that it didn't produce a lot of desegregation in the schools was that the chief law enforcement officer of the United States neglected and ignored his duty. His name was Dwight David Eisenhower. He didn't support the court. He was the most popular man in the United States. And if he said Brown is the law, I believe in the law. I believe that we ought to abide by what the court has done. And if it comes to it, I will, of course, use my powers as a law enforcement officer to do what is necessary to see that the court is obeyed. He didn't say that, but on the contrary, he leaked it out that he was opposed to Brown and thought that, as his words, appointing Earl Warren Chief Justice was the biggest damn fool mistake he'd ever made. Ultimately, I, as your parent, I'm old enough to be the parent of most of you, but as your plaintiff, I will say this. Brown absolutely changed my life. It made the career that you heard about a few minutes ago possible. Had it not been for Brown, I would probably now be a retired lawyer who had spent his whole life practicing law between Grand Rapids and Detroit. But Brown made the whole world open to me and to all kinds of people in my generation, and it is rolled down. Would we give up what we've gained in order to avoid the backlash? No way. What you do in struggle is to struggle for justice from the day you're tall enough to understand what's going on till the day you die. And the struggle is not a sprint. Some people in the civil rights movement, the old people, died and they were sad and depressed because it all hadn't been achieved in their lifetimes. So I began to think of it as not a sprint, but a relay race. And not a short relay race, but a long distance relay race. So I am buoyed by the strength of my slave ancestors who believed that one day their children would be free, and so they held it together and taught their children as best they could. And I hope that in my lifetime I am setting an example for my great-grandchildren who have yet to be born, that he did the struggle. Now, these kinds of struggles aren't for the faint of heart. They're not for scaredy cats. And they are for people who know that these kinds of struggles are tough, that sometimes you lose, and sometimes it hurts. So you go to bed and you get up the next day and you go out and fight some more. That's the way you do it, and you don't worry about backlash, and you treasure the achievements that your movement has produced. I can't speak for gays, lesbians, and pregnant youngsters, but I believe that they would agree with me. Thanks very much.
Thank you, Roger. I am now going to display my cruel streak, and I'm going to turn to Jeff and going to note that you have sometimes written admiringly of Professor Klarman's work and have taken a somewhat different view, not of Brown, but of some of the decisions that we've been talking about. And in particular, you've written about the fact that there is an important categorical difference between judicial decision-making and legislative decision-making, and that the quality of judicial decision-making also matters. And I'm wondering if you could talk a little bit about your views on those topics, and perhaps talk about whether all backlashes are created equal, or whether some of the things we've been talking about are, with respect to one decision like a Brown, are different from your views with respect to a decision like Roe.
Those are all good questions, but I'd like to get to the heart of the matter, because this debate was fascinating. Judicial craft matters to lawyers. So when I went to law school, I was upset about judicial activism, not because I was traumatized by the prospect of living under a conservative judiciary, because this was the 1990s and such a judiciary didn't exist. I was upset because I found it difficult to accept decisions whose result I agreed with, like Roe, but whose reasoning I was unable to find persuasive. And I took that sort of stuff seriously. Does that matter broadly? No, most people don't read Supreme Court decisions, and they don't care about the reasoning. But to the degree that Roe, in Robert and Riva's fascinating account, precipitated, although it didn't cause, this principled political backlash motivated by views of traditional women and of religious views about the nature of personhood, it was able to have the political influence it did only because of Roe. The truth is that only 20% of the country, even in the most conservative states, accepts these views of the role of women and wants to ban abortion in all circumstances. The new right loses when they're subject to political tests. It was only because, first of all, Roe, by protecting early term choice, allowed pro-choice women and men to vote for the GOP without fearing that abortion rights would be threatened. And more importantly, because the new right could portray Roe, plausibly, as an enemy of the late-term restrictions on abortions that most Americans, most Democrats and Republicans, many people even in this room, if the polls are to be believed, support, moderate late-term restrictions on abortions. By painting Roe as a radical decision, the decision transformed our politics in a way that's been a disaster for Democrats. It has made every judicial confirmation hearing into a referendum on a decision whose reasoning many of us are unable to accept, but we have to plead allegiance to. It's transformed the Senate and the House, whose leaders are persuaded to pander to their extremist bases, these interest groups, which rose in response partially to Roe, weren't caused by it, didn't arise immediately afterward, but arose because Roe nationalized the abortion debate, and has distorted this presidency and led us to live for the past 2 terms under a president who's more concerned about pandering to this anti-democratic conservative base that has no national majority than he is about representing the views of the majority as a whole. Was this all caused by the Supreme Court? Of course not. Of course it wasn't. But the Supreme Court, as Riva and Robert suggested, played a role in this dialogue. And the question that you put on the table, Eddie, I don't mean to dismiss your latest questions, but the first one you posed is the central one, and I want to answer that. Should liberals resurrect this heroic view of courts, look for a new vision, as Robert suggested, and imagine that by embracing some kind of robust new judicial liberalism, they can fight conservative judicial activism? This seems to me completely implausible. The Supreme Court is going to be in the hands of conservatives for the foreseeable future, even if a Democrat wins the next time around. The idea that there could be a meaningful, strong 5-vote liberal majority is a fantasy. So judicial activism will only redound to harm Democrats. And more importantly, it's always been a disaster for political movements that can win their points in the political arena, as the Democrats can. I'll close by saying this. I do have a vision. I think of it as heroic. One, it's certainly not mine, but I was inspired by it in law school, and I'm still inspired by it. It's a vision of bipartisan judicial restraint. I write for the New Republic magazine, where I'm the legal editor. The founders of the New Republic included Holmes and Frankfurter and Learned Hand, who thought of themselves as progressives and were upset by conservative judicial activism, and by resisting expansive uses of the courts, thought they could defend progressive values. This vision was continued through the 1960s by people like Alexander Bickel of the New Republic, who opposed Roe's reasoning, Eddie, as you suggest, but supported its result. And I've tried to keep it going till then. Whether you want to embrace this vision for reasons of strategy or for principle, it seems to me obvious that in an era where conservatives will control the courts for the foreseeable future, liberals should focus their energies on winning their points in the political arena. They've proved their ability to do so. And by wasting our time imagining, hoping, yearning for judicial salvation that never comes, we risk shooting ourselves in the foot.
Well, Jeff, I appreciate the battle is now joined.
Very good.
I had thought that the remarks you just made might have been your opening remarks, and I'm delighted you made them now. And Robert, I think I'm going to turn to you since it was your vision that I think Jeff was targeting right there.
I think it's a very eloquent statement, and I guess I want to respond in 2 ways. The first is, I don't think one should imagine this as either judicial or political. And the tradition of the New Republic that I would identify with is Brandeis, who precisely doesn't make that distinction, and who precisely sees a set of judicial rights flowing from a particular vision of the state, as Athens, for example, and that gives you First Amendment rights, and so forth and so on. So I would resist this notion of bifurcation. And I would say to us, yes, of course we're not going to control the Supreme Court, alas, for the next couple of years. But when you think about how it is that a judge who will come to power, whenever a judge on the left does come to power, and whenever you have appointments at other levels, where is that jurisprudence going to come from? Will that jurisprudence be assisted and aided if all that we have on the left is this notion, which you saw the left adopt strikingly and ineffectually in the context of the Roberts and Alito nominations of judicial independence, rule of law, and precedence? That position, from my point of view, gets you very little. What gets you something, what the opposition to those nominations should have been, as recent decisions are showing, is they've got the wrong idea of what courts are. They've got the wrong idea of what access to a court is. They've got the wrong idea of how you protect robust sense of equality and of liberty. That's what the opposition should have been. And it wasn't there because we haven't given yet a convincing progressive vision that is political, that from which can be derived a constitutional vision. And when we have that, we will have a constitutional vision that won't be bifurcated between the judicial on the one hand and the political on the other. They will flow seamlessly together. That's what the rights have made. You know, the right has mobilized in the name of a political vision, of a religious state, of traditional family values, of rights of property, and from that political vision has grown a judicial philosophy, which they call originalism. Of course, there's nothing to do with originalism. It's just a signpost by which this political philosophy is expressed. We need to do that. That's what I'm saying.
Could just very briefly, I embrace that resistance to bifurcation entirely. I was just responding to the way that Eddie phrased the question in a Manichaean way to get us going. But
That's my job, Jeff.
I know, I appreciate it. You're doing it very well. But Brandeis is a model I'd be happy to embrace, too, because he really was ultimately a democratic constitutionalist. He believed strongly in certain values, First Amendment values, that ultimately the public was willing to accept with his guidance and a dialogue with the court, but was tremendously sensitive. He was essentially a restraint man, sensitive to state experimentation, deferential to Congress, and always never made the mistake of imagining that judicial salvation could substitute for political activism. So I'm happy to join you on that one.
I just want to say one thing in response to Jeff's vision of social change emanating from Roe, and that is to sort of pause and urge a degree of caution, or invite you to read the history section of this piece, in treating Roe or responses to Roe as the cause of everything that followed. It seems to me extremely clear that Roe played an enormous symbolic role in this mobilization. But there's a long distance between the way in which groups who were opposing the ERA, concerned about the school prayer decisions, et cetera, came to talk about the abortion decision as a symbol of a certain kind of court that was wrong, not just because it exceeded Roe, but because it imposed values that these Americans thought not theirs, right? It's important to tease those two things apart. And I think you'll see something that's relevant here, which goes to the bifurcation point, which is, intriguingly, that even though we talk about the court as a counter-majoritarian institution and decisions as ending politics, it turns out that decisions like Brown and decisions like Roe and decisions like Bowers and decisions, they actually play an enormous role in distilling normative questions for a democratic polity and moving people to make claims on the meaning of their constitutional tradition. So that, in fact, they can, in fact, in a deep way, do lead to this integrated sort of response of democratic deliberation and participation that can have political democratic majoritarian dimensions as well as litigating and adjudicative ones.
One of the things that Reva just mentioned is the symbolic power of Roe, and I would say there are perhaps a few other iconic decisions that get held up the same way. Whenever I'm driving across Middle America and listening to talk radio, Roe is mentioned with remarkable frequency, and it does have this media-generated power, especially on the right. Scott, one thing I wanted to ask you, just to pick up on the theme that's been an undercurrent here a little bit, is, okay, if we're facing a court that might turn radically to the right, do you think in the modern era that progressives are capable of generating backlash, or is this really become a one-way ratchet, and that backlash phenomena is really a right-wing phenomena in this country?
And hopefully we won't find out, but my guess is that it would not be one-way ratchet, that if you had a Supreme Court that legitimately was to try Constitution exile, to strike down major parts of the New Deal regulatory state, I am quite convinced that that would have major electoral implications.
So you think 1937 could happen again, in essence?
That would be my guess, yes. Now, I think that's one potential danger, though, with the kind of clever minimalism of the Roberts Court, is that you're much less likely to get a backlash if you kind of hollow out precedents from the inside rather than overturning them explicitly. So certainly overturning Roe versus Wade and Casey would have a major backlash. Whether simply, we're not deciding anything about Roe, we're just saying that no abortion regulation is ever unconstitutional, that may produce kind of less of a backlash in a way. And I do think that we should consider that as a major democratic cost of minimalism. I sort of agree with Scalia in the campaign finance case that if you're going to logically overturn a precedent, we should be explicit about it. That I think that I think that the real minimalists, like Professor Sunstein, would say that that's not real minimalism at all, that it's phony or whatever. But I do think that that's one thing to worry about Roberts and Alito, is that precisely because they're not as explicit and kind of abrasive as Thomas and Scalia, they may be able to get away with a lot more. Although that couldn't extend to actually, striking down the Social Security Act or something like that. That would produce a backlash. I would hope.
I'd like to make sure to get to some of the questions that have come from the audience here. And Roger, I have one here that I think is well addressed to you, which is really has to do with a distinction between principles announced and means adopted. And that when we think about backlash, especially perhaps in the context of Brown, is the focus on backlash really about the principle that was announced, or was it exacerbated substantially by the means used, such as forced busing or other aspects of social engineering, to achieve some of the broader-based social goals?
I think the backlash was essentially against the principles enunciated. The methods used, particularly the attacks on busing and affirmative action, were tactical. Look, Klarman is right that you could not have gotten out of the Congress of the United States in 1954 federal legislation that decreed that schools should be desegregated. There were goons from the South in all the congressional spots where you could throttle legislation. And so, but these people, just a lot of the backlash people, could not envision black kids and white kids going to school together, and it wasn't just Southern. There was a lot of feeling like that in the North, in Michigan, for example, where I grew up, to the extent that now the state of Michigan is one of the most segregated places in the country. So, no, I think it was, I hate to tell you a secret, but there are a lot of white people still in this country who really just don't like black people. And that's the truth.
One way of thinking about this is that Brown and the court succeeded in altering the debate in such a way that opposition to Brown got deflected onto busing because that was permissible still to speak. And there's a deep way in which the success of Brown is that now everyone's fighting to control the meaning of Brown, basically. I mean, that's what we've seen in the recent DSEG cases. The whole question is whether you can express your worldview through a vision of Brown itself. But that represents something still by way of an advance over the previous world, as does Roe, no matter how tattered and torn it still is. It's standing in for some set of understandings whose meanings still have to be vindicated in politics.
Right. I mean, I think one of the defining moments in 1986 in the Rehnquist confirmation hearings was when he had to embrace Brown, a decision that, as a younger man, he had opposed. But what we now see, as you say, is the reinterpretation of Brown to fit a very different jurisprudential worldview. I suppose it's appropriate, given that this is an ACS event, that several questions have focused on the Federalist Society. And I'm trying to coalesce those questions, the suggested questions into a single one, and I think it might run something like this, and I'll pose it to Reva and Robert, which is the suggestion that legal reasoning doesn't matter because people ultimately care about results and the ultimate values announced in decisions is surely true on a global level. But haven't there been now more than one generation of law students inspired by a sense of intellectual betrayal at the court, that it's not just a question of disagreeing with bottom lines, but that in fact there's a bankruptcy about the liberal enterprise that has driven a very large cadre of younger law students and now not so younger law students who are in the executive branch and on the bench to create, what is, I don't know if I'll call it backlash, but I'll just say deep retrenchment and reversal. And so doesn't legal reasoning matter?
I spend my life teaching legal reasoning. I certainly believe it matters. The question is it matters for what and in what context? If you're professionals and you want to instantiate the rule of law, it matters your craft, and it matters that it be done right, and it's a matter of integrity, and it's a matter of the legal profession maintaining a certain degree of standards. But when one talks about the boundary between law and politics and how law comes to express political vision, which it does if it's going to be democratically accountable, that's the point we were making. I mean, if you imagine law as just simply having authority because somebody says so, that's a picture that may tell you why you stop at a stoplight, but that's not going to tell you much about constitutional values and the way they acquire authority. For that to happen, the person telling you something, you have to have some degree of trust in and recognize that person is speaking for you in some way. And so law and politics cannot be opposed the way any simple opposition of it does. Law has to take politics inside. Now, when one looks at the actual sociological and historical mechanisms by which that happens, it's a mistake to think that that boundary is determined merely by craft. That boundary is determined by very deep issues of political vision and ideology, and it's the task of us inside to make law by binding it in terms of norms of craft and reason. I don't think that the Federalist Society arose because judges were sloppy. I think that's just not a very good account of what happened. It arose because people disagreed with the welfare state, and they wanted a different form of politics, and then they created a form of law to match it.
I think it's really important to first disaggregate the space of the professional from popular response, to give each their due, that is to say, internal to professional legal academics and litigation. People know that there are norms of craft, the ability to distinguish better and worse, good arguments and bad arguments, and from an internal perspective, we can make these discernments. Nothing we're saying is calling that into question, and indeed you can even point to processes through which lawyers will assess the quality of an opinion, and eventually Jeff will tell us whether it's well-reasoned or not, meaning that there are ways that there's mediations between these worlds. There are also ways in which law students going through school learn things about respect and disrespect for different judges and different opinions, and these will ultimately reverberate in the world. All of these seem to me correct. I don't think, however, it makes sense to exempt the domain of professional reasoning, law schools, litigation law, from the sort of sphere of nomos and the sort of sense of social value that the public is in, meaning that the crystallizing symbolic power of judicial decisions has its pull on lawyers as well. And the space of social norms has its pull on lawyers as well. I mean, why is it that the the sex discrimination intermediate scrutiny cases, which have struck down every sex-based restriction on marriage that existed on the books in the past 20-something years, and did it probably within 6, have never touched sex restrictions to the definition of marriage itself. Why is it that intermediate scrutiny obliterated every single sex-based distinction in the law of marriage but the gateway one? That is professional reasoning reflecting something about, if you will, the heterosexism, or however you want to describe it, of the social order in which we're in. Also, people's understanding of what's plausible to argue to a bench, what's plausible for courts to find in the Constitution, lest they, as Jeff would tell us, make a declaration of meaning so deeply at odds with social understanding that their interpretation will not look like a Constitution that represents the understanding of we the people. So I think that there are ways in which these domains are distinct, that rationality deeply matters, and yet rationality is unfolding within a space that's deeply social.
Jeff, did you want to add anything?
Just one point, which is I think the Federalist Society offers a cautionary tale, obviously in many ways, for the American Constitutional Society, but in one way in particular that's relevant to this discussion. When I was in law school, I took seriously the promise of the Federalist Society, which was just getting up and running, to actually separate its jurisprudential conclusions from its political agenda. And I admired the promise of originalism, that it could actually achieve that goal. I was disillusioned, to say the least, and ultimately cynical when I noted that in all the important cases where the conservatives' history clashed with their policy preferences, the policy preferences won. And their failure to respond to the challenge of liberal originalists who pointed out their errors didn't increase my respect for the enterprise. Now you've been given an inspiring challenge by 2 of the most inspiring law professors in the country, which you should take seriously. And Robert and Reva have told you, go develop your own vision, American Constitution Society. As you do that, take seriously the distinction between law and politics, and don't see yourself, at least in this respect, as purely ideology-driven. Your goal as scholars and thinkers about the law shouldn't merely be to achieve liberal results, but actually to come up with methodologies that might, in important cases, lead your policy preferences to clash with your jurisprudential conclusions. That was the lesson of Brandeis, who was much more concerned about state experimentation because of his commitment to federalism than with achieving liberal results in every case. That was Holmes at his best as well. And regardless of whether you join my quixotic devotion to bipartisan restraint, I'd at least hope that you'll take seriously the promise of the constraining rule of law.
Jeff, as someone who admires your attempt to achieve golden rules, I will applaud you. And I'd like to maybe, since we're up against 1 o'clock, I want to end with a practical question for Roger to bring it down from the theoretical. I have a question from the audience, which is, in essence, do you think it's time, in light of the school decisions from this last term, to change strategies and to think about a legal regime based more on class differences than race differences, or would that be abandoning a moral high ground that we simply must keep?
I think that white people and black people and Hispanic people and Asian people in America don't know each other well enough. I think that the most important educational lesson I ever had was when I was 12 years old and moved to Grand Rapids, Michigan, and was enrolled in a high school with 1,200 white students and 1 black student. It was pure hell for a long time. And then it got better, and then it got better, but it was never perfect. But of all the periods of education I have had, that time in that school with those white kids taught me the most invaluable lessons I will ever learn. Number 1, there's no master race. Number two, us black folks have a lot of things to teach other folks, which if they will listen and pay attention, they will find have enriched them. So do I believe that we should still try to integrate our schools? Yeah. And do I believe that the class-based solution would achieve the ends that I have in mind? I don't think so. On the other hand, because the education of the poorest black kids in this country, the poorest kids, but particularly the poorest black kids, should be an enormous issue for us. I do think we have to take class into consideration when we assign kids to public schools. But essentially, I think I really am an integrationist because I think we all can learn from each other, and we ought to try very hard to do that.
Well, our time has expired. We could go on for quite some time. This is a wonderful panel. Thank you.